451st Judicial District Court of Kendall County, Texas. Ms. Thompson, would you please begin the announcements?
Jessica Thompson for the department.
Amber Wagner, Belong Adoption Specialist.
Shelley Choberman on behalf of the Franklins.
Jennifer Harris, attorney ad litem for the children.
Keith and Lisa Franklin were the maternal grandparents.
Amy Harding, Hill Country Casa, guardian ad litem for Xavier.
All right, Ms. Wagner, my understanding at this time, permanency goal remains relative adoption with the Franklins in Colorado, correct?
Yes, Judge.
And that at this time, that placement is safe and appropriate in meeting his needs, Xavier's needs?
So. Yes, sir.
And it's in his best interest to remain there?
Yes, Judge.
All right, is he up to date on all of his checkups?
Yes, sir.
And then he had a recent diagnosis of autism spectrum that has improved his care?
Yes.
Okay. Any orders that you're asking for in regards to his physical or mental health today, or do you believe everything's being appropriately addressed?
Oh, no. Colorado does such a great job. They are fully addressing, and the Franklins do such a great job advocating for them, for him, that I don't need to do anything.
Okay. And are his educational needs being met?
Yes, Judge.
And are the Franklins the education decision maker?
Yes, sir.
And they're also his medical consenter?
Yes, Judge.
And that's in his best interest?
Yes, sir.
Yeah. And his behaviors are overall good?
He's doing well. He's an active little guy, but he's doing well.
And he's bonded to the family and happy?
Oh, very much so.
And as far as he's had the opportunity to express his wants and desires as the placement, everything seems well?
Yes, Judge. I saw him last month, and so we talked about what was going on, and he's fully on board as much as he can be for being 6.
All right, that's good to hear. What barriers do we have at this point in time for the adoption? When we were here in June, it was the waiting period, and then the home study out of Colorado. What are we waiting on now?
I just sent some subsidy today. I received all the documentation. Subsidy was sent off right before court, so hopefully within the next week or so, they'll be able to get with them to do subsidy negotiations.
Okay. And then what do you think as far as the timeline goes?
I mean, adoption's already been filed, so as soon as we can get subsidy, as soon as I get subsidy back, then I will figure probably a week and a half, 2 weeks.
Okay. And where was the adoption filed?
Oh, in Kendall?
Okay. Okay. Ms. Thompson, do you have any questions for Ms. Wagner?
Ms. Wagner, how is Xavier with individual play therapy?
He has individual therapy like once a week. They do let him see more often. I know during the summer he was having more therapies just because of the schedule, but he does see a therapist at least once a week and is doing well, making progress.
Okay. No further questions.
Ms. Troberman?
I'm just checking my notes real quick, Your Honor. Well, hang on one second. There was a question, and Amber, I'm not sure if you're the right person to ask about this or not, regarding a CANS evaluation that they were having trouble getting done.
Right. We asked for the CANS because the CANS was due, I think, back in September, but I don't believe that is something they do in Colorado. And so we were trying to figure out if there was like another version that they could do or where we needed to leave that.
Okay, and are we still trying to figure out if there's like a Colorado equivalent to that evaluation?
I was working on that. I'm going to get with their worker in Colorado. She's been out, so I want to get with her and see if maybe she can navigate that a little bit for us.
Okay. Now, there was a question regarding the adoption assistance paperwork. Has all of that been, I mean, that's what you were just testifying about a minute ago. I'm assuming that all that's been done and sent off, and now we're just waiting on it to be returned to you. Is that accurate?
Yes, ma'am. I just sent it right before court because I got the paperwork about 10 minutes before that. So I was able to compile it and send it today.
Okay, and then the only other question they had or that we had to do with some of the summer payments. I know we talked about that in previous hearings, and they did receive one check from the Child Welfare Board, but that was it as it pertained to like some of the camp assistance and stuff that they thought they were going to receive this summer. Is there any update there?
I will double check. I will get with our person and see where that is. I apologize. I did not realize that we had not gotten that all figured out. I will do that as soon as we get off court.
Thank you. That's nothing
Sure.
further, Your Honor.
Thank you, Mr. Oberman. Ms. Harris?
No questions, Judge.
Anything else from the department?
Nothing further, Your Honor.
Anything else from you, Mr. Oberman?
No, Your Honor.
Ms. Harris?
No, Judge. Miss Franklin sends very detailed reports each month on how they're doing and what they're doing. I appreciate those, especially with them being so far away. It really helps. They keep him really busy and they are meeting his needs. So we're just waiting on the adoption.
Ms. Harding?
Thank you, Judge. I agree with the attorney ad litem and the department. Xavier is doing extremely well with his grandparents. I had an opportunity to go visit at the end of the school year. We had a delightful time. I got to see where he's living and how he engages with the family. And I just can't think of a better environment for him to grow up in. They are meeting all of his needs, and we are just anxious to see an adoption setting.
Thank you. For the purposes of the permanency review after final order, the court finds that the permanency goal of relative adoption remains in the best interest of the child. Court finds that placement with the Franklins is safe and appropriate, meeting Xavier's needs and in his best interest to continue. Court finds that he's up to date on all of his checkups. And that his autism spectrum diagnosis is being appropriately addressed. No further orders there. Court finds his educational needs are being met, and that the Franklins, being the education decision maker and the medical consenter, are in the best interest of the child. Court finds that he is overall exhibiting good behavior and bonded to the family, that he has expressed his wants and desires and had the opportunity to tell Ms. Wagner other parties how he feels about the placement, and that since our last hearing, no other family members have come forward. Court finds that the only barrier to adoption at this time is paperwork, and that paperwork has been submitted. I'll find that Belong has made reasonable efforts to request and negotiate subsidy to work with the placement and maintain contact with them and Xavier to visit the child, and again, negotiating the subsidy. Our next hearing is scheduled for April 9th, 2025 at 11 a.m. April 9th, 2025 at 11 a.m. But I hope we have had an adoption long before then, and that hearing is smooth. That's my hope.
That's my plan.
Let me know if there is anything else that the court can do. If not, thank you, Mr. and Mrs. Franklin, for all you're doing, and thank you everybody else for your time and your services. I'm very pleased with how everything's going.
Your Honor, I think there might be some psychotropic meds.
Oh, do we miss
go over
that?
those for the order?
Is he receiving psychotropics at this time? I didn't think I saw that, but
He is on Adderall and Abilify.
okay. Then I missed it. Okay, and were those reviews up to date?
He had a review in September. He had a follow-up in October, and he's at another appointment pending in December.
Okay. Well, I mean, with the behaviors that I'm hearing he's got, sounds like those are probably where they need to be, but we'll leave that in the doctor's hands. Okay. Thank you all for your time and your service. Nothing further. All parties are excused.
Thank you, Judge.
Thank you.
Thank you, Judge.
Is Miss Byers here?
I don't see her on, Judge. Let me see if I can get in touch with her because she did say that she was going to jump on.
Okay.
With
I don't
Tom's
see her either.
iPad.
I don't know who that is at Tom's iPad. I've just had somebody join. It says anonymous.
That
Whoever's
could be
there
her
under-
husband, Your Honor.
I'm sorry.
That could be her husband. I think his name was Tom.
Hi, my name is Tom. I am actually Aiden's grandfather. So I am Tamika's stepdad, and she asked me to join.
Okay. Do you know where she is?
I was just speaking to her about 20 minutes ago. She said she was getting ready to also join this call.
You said your last name is Byers too?
No, it's Paracchio. You need me to spell that?
Let me see if I can get it right. Perrachio.
Very close. One R.
Okay. Thank you. All right, let's see if Miss Byers joins us. Have the attorneys had an opportunity to confer?
I'm going to text her now.
I haven't conferred with anyone, Your Honor.
I was going to put.
I mean, I conferred with Miss Acevedo.
Okay.
I just text her. Hopefully she responds. Yeah, I just talked to her about 20 minutes ago.
I know.
She's calling me. You need to jump on, Tammy. What's it say?
Your Honor, were you going to put this?
That's what you have
Yeah,
to do.
room 1 is open.
So you click the where the microphone is?
Excuse me. Is Miss Byers here? Oh, okay. The person with anonymous as your name, could you please unmute and state your name?
But you don't, maybe they don't want background noise.
Miss Byers, is that you?
Okay, now. I should be on there. What is going on here? Oh my God.
Miss Byers, can you hear me?
No, I can't get back onto the.
Give me your answer.
Right.
That's cool. They're just doing it. They're controlling it. They're making it.
But the attorney for Miss Byers is sharing some information with the other attorneys. They're going to continue to confer, so we'll continue to be in recess. All right, good afternoon. We're going to go ahead and get started here. Miss Thompson, would you please begin the announcements?
Jessica Thompson for the department.
Rochelle Acevedo, for the mother, Tamika Byers. She's present. Miss Byers, can you please announce?
You'll need to unmute Miss Byers. All right, the court will take notice that she's here. If she can't get unmuted, we're going to have to move forward. We've already been at this for an hour and 10 minutes.
Deborah Fuller, attorney for the child, Your Honor, ready.
Mark Snack, Memorial Country Casa.
All right. my understanding, I'm not going to swear anybody because my understanding is we're not going to be taking any evidence. We're here for an adversary hearing, and it's my understanding the parties are going to request a mediation. Is that correct?
Yes, Your Honor.
Okay. I believe it's appropriate in this case. Ms. Greenlee, the parties have agreed to mediate on December the 3rd. Can you give me a date after that for us to continue this mediation, or excuse me, this hearing?
We can set it on the 11th because that's the status hearing.
All right, that's what we'll do. What time?
10 o'clock.
Okay. So I'm ordering the parties to mediation on December 3rd, 2024. The only people that should be at this mediation are people who are named parties in the case. Don't bring any family members, don't bring any spouses, no parents, nobody. It should be the Miss Byers, the attorneys, CASA, and the department. Those are the only people that are allowed into the mediation. We're going to reset the adversary hearing to December 11th, 2024 at 10 a.m. December 11th, 2024 at 10 a.m. And just for the purposes of the record, I will reset this outside of the statutory period based on good cause and agreement of the parties to mediate in a pre-262 mediation. So I'll need the attorneys to sign the order resetting pursuant to the family code, please. I also want to state on the record that I did speak with Aiden last week on Friday. He requested to talk to me with his attorney, and we had a brief conversation. So I'm aware of what Aiden's wants and desires are in this case. And I think if the parties are able to have a discussion at a mediation, maybe we can come up with some alternative resolutions that would be beneficial to everyone involved rather than the court making orders. But if you can't come to a resolution, then I will make orders on the 11th. So I'm going to continue the emergency order, and all parties are ordered to sign that reset order. Anything I failed to address?
No, Your Honor.
Okay. Thank you all for your time and your service. If nothing further, all parties are excused. I'll see you December. All right. I want to make sure that I know exactly how we're proceeding this morning. We're set for an adversary and a status. I've got a note. Well, that was from our last hearing, actually. I'm sorry. I'm thinking it was a newer note. Did you all reach an agreement, or do we need a contested hearing this morning?
We have an agreement, Your Honor, except on a couple things that we were going to bring forward to the court, but we have a MSA.
Okay. In the 451st Judicial District Court of Kendall County, Texas, court is streaming outside of Kendall County. Any objections?
No, Your Honor.
No, Your Honor.
No, Judge.
Okay. Then Ms. Thompson, would you please begin the announcements?
Jessica Thompson for the department, ready to proceed, Your Honor.
Katarina Lewis, Belong Permanency Specialist.
Ashley Crouch, Belong Permanency Supervisor.
Deborah Fuller, attorney ad litem for the child, Your Honor. Ready?
Mark Smackmore, Hill Country CASA.
Aaron Lamont, Hill Country CASA.
Ashley CPI.
Ms. Espinosa, you have my permission to turn off your video so we can get maybe some bandwidth directed towards your voice because you're breaking up a little bit. Do we have Ms. Byers here?
Yes, Judge, she's present. She's on the phone, 897.
All right, Ms. Byers, can you please hit *6 to unmute and state your name for the record?
Good morning, Your Honor. Good morning, Your Honor. Tamika Byers.
Yes, sir.
Thank you, ma'am. All right. I think somebody else was just talking. I'm not sure who that was. All right. All right. what are the terms and conditions of your mediated settlement agreement that are, let's go over the agreed stuff first, Ms. Thompson.
That the department will be named as the temporary managing conservator. Ms. Byers will fully engage in the family plan of service, with the exception of submitting a hair drug test and completing a psychological evaluation, which is left to determination of the court. Ms. Byers agreed to submit the urinalysis drug test at her own expense for the next 14 days and agrees to execute necessary releases for the results to be directly provided to and obtained by an department or belong. Ms. Byers also agrees to submit an FBI background check at her own expense within the next 14 days and agrees to execute any release necessary for the results to be sent directly to the department and belong. And parties agree belong shall conduct a virtual walkthrough of Ms. Byers' home the next 14 days. Parties agree that Ms. Byers is allowed to send letters and video messages to her son via the belong caseworker, Ms. Katerina Lewis, who shall provide them to the child's therapist to determine their appropriateness for the child to read and review during therapeutic sessions. Parties agree no contact of any form shall be taking place between Ms. Byers and the child's placement. Parties agree that documents concerning the child's well-being, education, psychotropic medications shall be provided to Ms. Byers and to her attorney within 48 business hours of receipt. Parties agree the department and belong shall provide bi-weekly updates to the mother as to the child's physical, emotional, and mental well-being, to include updates related to the child's educational status, extracurricular activities, and psychotropic medications. Parties agree no medical support or child support for the child is ordered at this time. And parties also agree the use of electronic, right. And those are terms of the agreement.
Ms. Fuller, is that your understanding?
Yes, Your Honor, my understanding is that that is the agreement and that the issue of the hair follicle and psychological evaluation will be brought to the court to determine that today.
Ms. Acevedo?
Yes, Judge, that's our agreement outside of those two things.
Ms. Lenoir, is that your understanding of the agreement?
Yes, Costa agrees with that as well.
Okay. Ms. Byers, did you hear the agreement?
I heard the agreement, Your Honor.
Is that the agreement that you made?
Yes,
And did you have an opportunity to discuss that with your attorney?
I did.
And do you understand the agreement that you've made and how it pertains to you and what it obligates you to?
I believe I do.
And was your agreement voluntary, or were you forced in any way or made any promises to get you to agree to it?
No.
And are you asking the court to approve this agreement today?
Yes, Your Honor.
Okay. Miss Lewis, without going into anything that was discussed at mediation, that's obviously confidential, are you giving testimony on this, Miss Lewis?
Yes, Your Honor.
Okay, you were just thinking about what I was saying because you made a face that maybe I was supposed to call somebody else. Okay. Can you help me understand why these terms exist in this case and why they're in the best interest of the child?
They are in the best interest of this child right now as we address Aiden's mental health concerns. And they're in his best interest.
Okay, so my understanding as I listen to this is that these are specific custom provisions for this particular case to to take into consideration the fragile state of his mental health, correct?
Yes,
Okay. And so you believe that starting this case with this sort of contact prohibition and the steps that you all are asking mom to complete, that's in his best interest.
I do believe that, yes.
Okay. Tell me your position on the hair test and the psych eval.
I think a hair test would be helpful to just get a baseline as to where we're at. Aiden has let us know that there's history of him remembering of drug use back in the day. And then a psychological, I think it can just give us a better background of Miss Byers' history. And it also can be beneficial to her.
And then the psych eval, was there some particular reason why that was not agreed that hasn't been discussed yet, or was it just an objection to being subject to a psychological evaluation?
I believe it was just an objection to having a psychological evaluation.
Okay. While I'm asking you questions, we're also set for the status hearing today. So did y'all create family plans of service?
Yes, we did.
Plan of service. All right. Does that family plan of service mirror what the terms of the mediated settlement agreement are, except for those two issues?
Yes, it does, but we do have the psychological and hair test in that family plan of service.
Okay. So those are the only two exceptions to everything else that was agreed.
Yes.
All right. Do you believe the family plan of service as it's written is appropriate in the best interest of the child?
Yes, I do.
All right. And as far as the placement of the child at this time, is the statement appropriate, meeting his needs?
Yes, it is.
Is it in his best interest to continue there at this time?
Yes, it is.
And you talked about his mental health issues, or all those concerns are being appropriately addressed and they have adequate resources to help him.
Yes, they do.
Okay. Is he up to date on his medical, dental, and vision checkups?
Yes, he is.
What do you think about school?
He's doing well in school. He has started at Judson High School recently, and he is actually attending school. We were having a little issue at the beginning of this case with Aiden not wanting to go to school, but since he's moved to Miss Jordan's house, the fictive kid home, he's been attending school, and she hasn't gotten any I guess text messages that he's missed or skipped. So that's good.
Okay. And do you believe, this goes back to the adversary and the status hearing, do you believe that there was a danger to him caused by an act or failure to act of the mother or any other person that was in control of him, and that danger required his immediate removal?
Yes.
And do you believe that removal was necessary to avoid any future instances of abuse or neglect?
I do.
And you believe that the department, made all reasonable efforts to avoid a removal and return the child home?
Yes.
And do you believe that there was a continuing danger that prevented the child from being returned home?
Yes.
You're asking the court to order this adversary and approve this agreement, and then for the status hearing, you're asking for the court to make the family plan of service an order of the court and maintain the placement?
Yes, I am.
Right. And you believe that all of this is in Aiden's best interest?
I do.
Is there any Indian child heritage in this case?
No.
Did you develop a permanency goal in your family plan of service?
I did.
What is the permanency goal?
Family reunification with his mother.
Right. Ms. Thompson, do you have any questions for Ms. Lewis as to either the adversary or the status hearing?
Yes, Your Honor. To the status hearing, Ms. Lewis, did Ms. Byers, the mom, receive her family plan of service?
Yes.
Okay. And Ms. Lewis, what are the exact recommendations suggested by Belong for Ms. Byers?
We are requesting that Ms. Byers complete parenting class, well, NAMI parenting classes specifically to address Aiden's mental health concerns and understand that. We also ask her to complete a psychosocial assessment and have an individual counselor. We are also asking her to do that psychological evaluation along with that hair follicle and then that initial UA. And then the last thing would just be to have a safe, stable home and be able to show us income, a proof of income.
Okay. And as to the adversary hearing regarding the MSA, did Ms. Byers schedule UA drug testing? Did she follow up with you regarding that?
I have not heard from her, but I'll follow up with her.
Okay. I pass on the witness, Your Honor. No further questions.
Ms. Acevedo.
How long has Aiden been in his new placement?
It's been there for about 3 weeks to a month.
Okay, and have you seen improvement in his behavior?
I have actually.
Okay, is he continuing with his therapy?
Yes, he's actually on December 18th. He has an appointment with the Children's Bereavement Center in San Antonio, and he's going to start that grief therapy. It'll be individual therapy along with group counseling, and he will be able to relate with youth that have gone through the same thing as him.
Okay, so he's just going to start next week.
Yes, we just got him in. That's the earliest they could get him in.
Okay, and I guess there was just a delay because he was receiving therapy while he was in the RTC?
Yes, he was receiving therapy there, but that was just an RTC therapist, so we had to switch over once he got out of there.
Okay, and is this going to be weekly therapy?
Yes.
And you said bereavement. Is it solely for bereavement, or are they going to be addressing everything?
We are going to look for a specific mental health counselor for him, so an individual counselor. I will follow up with the placement. She was looking for that at the time.
Okay, and I know that there's a lot of moving parts. We have the grieving process and we have the mental health issues, but which therapist is going to address the reconciliation and reunification with mom?
I believe that the bereavement therapist could address that, but also an individual therapist could address that. I think both of them could do that with Aiden and mom.
Okay. And who's going to be the legal worker?
I'm the legal worker.
Oh, you are okay.
Yes.
You indicated you haven't had any contact with mom?
I reached out to her the other day on text message. I don't know if she got my text or not, but I will continue to reach out.
Okay. With regard to the things that she has to do, which is the UA and the fingerprint, do you know if there's anything that the department has to submit on her behalf?
I do not believe there is anything on our behalf that we have to submit. She will just have to go find those.
Okay. If there is, can you please help her with that?
Absolutely.
Okay. I'll pass, Judge.
Ms. Lewis, in regards to the UA test, Ms. Byers under the MSA agreed that she would at her own expense provide that UA and then get the releases signed. So there's nothing that Belong can do in that regard, correct?
Correct. That's my understanding.
And Ms. Byers is in California, correct?
Correct.
She also agreed under the MSA that she would submit to the FBI background checks at her own expense within 14 days and then sign releases. And there's nothing that the department can assist her with there, is there?
No, there's not.
Have you been able to conduct a walkthrough of her home? That was supposed to be done within 14 days. It's been a week since we had mediation.
I have not been able to, but I'll get that done by next week.
Okay. And you said that you've had no contact with her since our mediation?
Correct.
And when Belong and the ad litem requested the hair follicle, did you have information from the child that he felt the mother had a extensive drug history?
Yes,
And so do you think it's important to get a baseline to determine if there is an issue?
I do.
And the fact that the mother agreed to do a UA within 14 days really is not going to provide much information, since most drugs are out of your system within 72 hours, correct?
That's correct. Yes.
So you're requesting the court because you feel it's very important to establish this baseline and to ensure, because she is in California, that there isn't a drug and alcohol issue.
Yes.
And in regards to the psychological evaluation, Aiden has some mental health issues, correct?
Yes, he does.
So wouldn't it be important to also have a psychological evaluation of his mother to determine if there are also any issues with her?
Yes.
And in regards to the family plan of service, for the psychological evaluation, Dr. Moran in Texas is willing to do that evaluation at no cost to Miss Byers.
Yes.
And Dr. Yates is willing to provide therapy, and she's at no cost to Miss Byers.
That's correct.
And have you set up the therapy with Dr. Yates yet?
Yes, I reached out to Dr. Yates, and she said that she can start seeing Miss Byers in the early January. She still has a few clients that she's finishing up, but sadly right now she's kind of the only one I have as an option since Miss Byers is out of state.
And part of the family plan of service would also be family therapy if Aiden agrees to that.
Yes.
And in your assessment of Aiden, how is he feeling at this moment in regards to any contact with his mother?
Aiden has reported right now that he does not want contact.
And have you received any letters or any items from Miss Byers?
I believe my supervisor did receive a Bible, but other than that, we have not received anything.
Okay. And at this time, is Aiden also refusing to accept anything from the mother as well?
Yes.
Okay. And are you asking the court to admonish the mother not to contact the placement?
Yes.
And were you able to get Aiden's shop records and to make sure everything was taken care of to get him enrolled in school?
Yes, we were. We were able to get that figured out.
And Aiden recently had a health issue that may require surgery in the future. Did you contact the mother and provide her that information?
Yes, I did.
And have you gotten her permission for if surgery, when the surgery will happen? I mean, excuse me, Your Honor, her permission for sedation for the surgery, because that will be necessary.
Yes, she has consented to that.
Okay. I'll pass the witness.
Anything else, Ms. Thompson?
No, Your Honor.
Any other witnesses from anybody else?
No, Your Honor.
Let me hear argument, and I'll hear from Casa at the end. Argument as to the stock valuation and the hair strength test. Ms. Thompson?
Your Honor, given the testimony provided by Ms. Lewis and Aiden's concerns regarding his mother's past history of drug use, it's very, very important right now for Ms. Byers to do and submit a UA drug test, as well as to do a hair drug test. And also, given the situation involving Aiden's mental health concerns and seemingly concerns within the family, it is just as invaluable for the mom to complete a psychological evaluation. I think it's in the best interest for Aiden at this point to do her due diligence with those two things that are also recommended by her family plan of service.
Thank you. That's not the
Judge, my client is willing to take a UA. She doesn't necessarily think either is actually necessary. But with regard to the hair follicle, Judge, she feels like her history speaks for itself. She has a longstanding history of steady work. She's raised two other children. These are accusations that are made by a child with severe mental health issues that she hasn't seen in almost 4 years after he was taken by his father and taken by default without any service or notice to the mother. So she doesn't feel like she has any history with regard to any type of substance abuse or drug history. She doesn't have any criminal history. She doesn't have any CPS history. I think that there was a referral that was ruled out. With regard to the psychological, I think it stems with the same argument, Judge, that there's no history of mental health with regard to Ms. Byers. I think that she feels like that's protected health information. I think she feels like the history is reflected in the history of the father. And so she doesn't necessarily believe that that is necessary. And Judge, just kind of while I have the floor, these are sort of outside. I know that part of the MSA was that she would provide the FBI fingerprint. California seems to be a little bit different. It is asking that she, as the applicant, provide a request for a BCIA 8016 form. So she has made these attempts, and they are asking for a specific form, which I believe needs to come from the department. I know that doesn't make sense to us as people from Texas. That's not how we are running it or how we're used to it. But she, again, has made these attempts. She's reached out to me. I've tried to figure out what this form is, but I do believe that needs to be submitted to the department by her and then submitted to them by the department. Additionally, Judge, with regard to the ICWA, my client has indicated that she has Blackfoot and Cherokee. And then outside of that, I think, Judge, my client just wants to some clarity. I think that there was testimony that Aiden was removed from her. I think that she just wants to clarify that obviously he wasn't removed from her. She hasn't seen him in almost 4 years, Judge.
Okay, let me back you up a step on this form. Is there something that the court needs to order, or just making me aware of it?
I mean, I think if I were to ask anything, it's just ordering the department to, I guess, be in compliance. I don't know. I'm assuming, Judge, that it is something that would come from the department.
Okay, so essentially an order for Belong or the department to work directly with Ms. Byers in the state of California to make sure that whatever they need from her or whatever California needs from Belong or the department, they get it.
Yes, Judge. The specific language, Judge, that I'm reading is that the applicant agency will provide the applicant with a BCIA 8016 to request for a live scan service. So they will not provide it without that form.
Okay. I think what I would do in that case is order you all to staff that, the attorneys to staff it and figure out the law on it. It shouldn't be that difficult. You know what statute you're looking at to be able to determine the authority and the breakdown of who's got to do what under that statute. I know it's a California statute, so you all have to be careful not to engage in any unauthorized practice of law. But it's something that I'm sure the department could get with someone to figure out if you're actually under a duty to comply with that, and maybe go through state officer appellate to figure out the answer to that question. And then regarding the issue she has with, I think I said in my my questioning to Miss Lewis is that it's the act of the parent or some other person, but I'm going to make my official findings like I do out of the family code, so that'll address that issue. Miss Fuller, argument as to the psych eval and the hair test.
Yes, Your Honor. Although Miss Acevedo says her history speaks for herself. That's why we asked for the FBI check. No one is aware of her history as far as the criminal history or any other history. That's why the FBI check was necessary, because we're not aware of that, and Belong cannot get copies of criminal histories from California. Her CPS history was an emotional abuse case. It was ruled out, but it was concerning enough that CPS was involved in Aiden's life. And the bottom line is this is a 15-year-old child that does not want contact. And maybe if he knew that from his memory, his mother had issues with drugs and alcohol and mental health issues, maybe if he was, it was confirmed that she doesn't have the drug or alcohol issues anymore and that her mental health issues are being addressed, maybe he would be more apt to have some contact. He is adamant at this time, based on his memories. They may, she may feel they're not accurate, but those are his memories. And in order for him to move forward, if the plan in fact is family reunification, it would be beneficial for him to know that his mother is clean and sober and her mental health issues are being addressed. And so I think it's important that you order both the hair follicle. Again, we had the mediation on December 3rd. We're here December 11th. We haven't even received the UA, so I think it's very important that you order the hair follicle and the psychological evaluation, because we need to have a baseline and see where this mother is coming from. There was some really aggressive behavior in the beginning of this case, and so I think there may be some issues, and I'm not a professional in that area, but I think we need to have it addressed, and I think it will maybe open up some doors for Aiden, but I think it's really important that it be ordered. I also think that she needs to fill out the Indian Child Welfare Questionnaire. If this is the first I'm hearing of any ICWA issue, and we need to know if she is a registered member, or we need to get that information as soon as possible.
Thank you, Ms. Fuller. Mr. Wong, anything else from CASA?
Morning, Your Honor. I totally agree with Ms. Fuller, what she said. There's only one way, and the best way to clear up all these allegations is to comply with the hair follicle and the psych eval, where there's no, it basically clears everything up. So I definitely agree with Ms. Fuller.
Thank you.
Sir, we also think that the current placement is in the best interest of Aiden, and he's doing well there, and we'd like to continue that.
Okay. Thank you, gentlemen. Ms. Thompson, any rebuttal?
No, Your Honor.
All right. Thank you.
And Your Honor,
go ahead.
I'm sorry. I did want to, say that I have met with Aiden over the weekend. He's doing much better than when I last met with him. I feel like he feels safe in this placement. I feel like the placement will meet all of his needs. She was trying to get him in as soon as possible for the bereavement therapy. She's actually looking at equine therapy as well. And he seemed interested in that. And so he's going to school, and he does seem happier. Unfortunately, he is very sad about what happened with his dad, and he really needs this bereavement therapy as soon as possible. But she was right on it. She just couldn't get an appointment right away. So I'm very happy that he was able to be placed in this home and not sent to Houston.
Good. I'm glad to hear that. So I'm going to just rule on the adversary, and then I'll rule on the status. Regarding the agreement of the parties, the court will find that agreement, all the agreed terms were in the best interest of the child, and the court will make that an order of the court. Court's also going to find that at this time, there's no Indian child heritage in this case. Miss Byers, you need to complete the appropriate paperwork that Miss Lewis can get to you, so that there can be a search and a determination made. And that needs to be done pretty quickly. That's anytime there's a suggestion that somebody may be affiliated with a tribe, be a registered member, the department and Belong have to move on that pretty quickly, but they can't do it without the information from you. So please provide that. And until you do, there's not much the department can do to find out if this case falls under ICWA jurisdiction. But if it does, we'll act on that swiftly. Court's going to find that for the purposes of the adversary hearing, the parties' agreement is in the best interest of the child, and the court finds, based on the testimony, that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. I want to make it clear on the record that Ms. Fuller, what day did I meet with Aiden? Wasn't it about 3 weeks ago?
Let me look at my notes.
Exact date, but I think it was somewhere around 3 weeks ago. I did meet with him. I did talk to him, and he opened up to me a little bit and helped me to kind of understand why we were in this situation, and that's why I asked Ms. Lewis earlier the questions I asked, because I wanted to know, since I had talked to him, if there had been any new developments leading to these particular orders, or if it was kind of the same thing. Did you find the date?
November 8th, Your Honor.
Okay. So it's been a month. Thank you. After speaking with him, and obviously I can't divulge anything he told me and Ms. Fuller in private, there's obviously a disconnect, and the orders that were made based on the agreement of the parties, all of that is very appropriate to me. I'm not going to repeat it all. You all have your MSA. Let's just make sure that those things get into the order. But I'm making the terms and conditions of the MSA the orders of the court. But if there's a disconnect between Aiden and Miss Byers, and there's a concern that exists, it's there for a reason, and I may never know the reason, but I know that disconnect is there. And one thing, Miss Byers, I don't know if you completely understand about these cases, that the overriding principle that we operate under is the best interest of the child. That trumps everything else. So if there's a concern that is directly related to the best interest of the child, I have to be thorough. And I cannot be thorough if I fail to lift up every rock and look under it. So I'm going to order the hair strand test, and I'm going to order the psychological evaluation. I've heard testimony, and after meeting with the child, reading the affidavit in this case, those things are appropriate. And if there's nothing there to find, then this should not be that big of a concern. If there is something there, then we know what we're working with, and we can address those things. We expect there to be issues when a case begins. We do not expect people to have a perfect record or a perfect lifestyle. That's why these cases exist. And if we figure out what those things are, then we can address them, and we can work with them, and we can move forward, and we can repair bridges and repair relationships. So on both accounts, on both sides of that double-bladed sword, this is a positive for the best interest of the child and potentially for the relationship. So I agree with Ms. Fuller. That'll be the order there. As far as the status hearing, the court's going to find that the family plan of service that's on file and was created by the parties is in the best interest of the child. The court's going to make it an order of the court. Going to order below to make sure, if not already, that mom has a copy and that she's reviewed it and signed it. Going to find that the placement is safe and appropriate, meeting Aiden's needs, and it's in his best interest to continue there at this time. Court finds that he's up to date on his checkups, that his educational needs are being met, and that his mental health needs are being met. Is he receiving any psychotropics at this time? I did not ask you that.
Yes. Oh, sorry. Go ahead, Kat.
No, you're good. Yes, he is. Yes, he is.
That
They
review
are
up to
being
date?
addressed.
The review is up to date?
Yes.
Okay. And so I'll find that his psychotropic, he is receiving psychotropic medications. They are being reviewed timely. And I'll defer medical support and child support at this time as agreed. I have to admonish you, Ms. Byers, not to contact the placement in any way, shape, or form. We obviously have to repair this relationship. We have to figure out where we are and what's going on, and I've already settled that. We can't do that if we don't follow the steps. These are cases that begin with a lot of restrictions, but if those restrictions are followed and the orders are followed and the concerns are addressed, then the restrictions start to fall away. If the opposite happens and the orders aren't followed and the restrictions aren't followed, then the restrictions get worse and worse as we move forward. So please don't contact the placement or do anything that's outside of what's been ordered. I'm going to order. Yes.
Oh, I'm sorry. Could you admonish the mother not to dye or cut her hair or alter her hair in any way for the hair follicle?
That is part of the hair follicle order. It's standard. If I order you to do a hair follicle drug test, you cannot alter your hair. That includes coloring it, bleaching it, cutting it, anything. Whatever you would not normally do to your hair on any other day, don't do it in advance of your hair follicle test until you've been tested. If you do something drastic to your hair that causes an issue for the test, then you're putting me in a situation where there's really only one thing I can infer from that. I'm going to order Belong to work with Miss Acevedo and Miss Byers in the state of California and for the parties to staff that form regarding that information. Again, please be careful not to enter into the unauthorized practice of law by giving any advice or taking actions based on California statutes and California paperwork. Please follow proper protocol. Make sure that if there is anything that needs to take place between the parties in the state of California, that it's something everybody's authorized to do. Our next hearing is going to be March 12th, 2025 at 10:30. March 12th, 2025 at 10:30. I have to admonish you, Ms. Byers, the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction or termination. Somebody say something.
I did, Judge. I apologize. My client is asking if she could have permission to speak to Aiden's physicians. I mean, she obviously doesn't have any contact with Aiden. She's getting limited updates, but he has pretty severe mental health issues that she's concerned about. He's on several psychotropic medications, so she would like the opportunity to speak to these physicians herself.
Well, what I'm going to do is direct you and your client to work with Belong and figure out, and Ms. Fuller and Casa figure out the best way to go about facilitating that and what's appropriate, what's not appropriate. I can understand her wanting that information. And I think depending on what we're looking at, she's certainly entitled to know what's going on with her son, but I also don't want to order something that's going to create some sort of workaround that vitiates the point of all the other words that we've made as far as contact goes. So you all talk about that, figure it out. If you need the court to make a clarifying order, please let us know and we'll be happy to do so.
Thank you, Judge.
You're welcome. Anything I failed to address? No? Okay. Ms. Byers, I know you're probably not happy with part of my decision today, but I need you to understand that I would love for you and Aiden to have a relationship if it's possible. And the only way we're going to get there is by being thorough. So just please understand that this is a movement towards reunification, or at least a rebuilding of a relationship at the very minimum. All right. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you, Judge.
Thank
Sarah Woods, Hill Country Casa, case supervisor.
Judge, Ms. Castro was just admitted. I would like to ask her to unmute and announce.
Ms. Castro, can you announce, please? You have to unmute. Y'all can go ahead and continue with announcements while we're waiting for her to get unmuted.
Robert Castro, I'm the father.
Gina Castro, I'm the grandmother.
All right, well, Ms. Castro is not able to get unmuted, so we will take notice that she's here. And for everybody else, Ms. Castro, oh, there you're unmuted.
Present.
Can you state your name for me, please? Ms. Castro, can you state your name for me, please?
Amy Castro.
All right. Can anyone who's not an attorney or will be giving testimony, please raise their right hand? All right. Mr. Robert Castro and Gina Castro, if you could unmute and answer in the affirmative so that the recording picks you up, please.
I do.
Thank you. Thank you.
Judge, I hate to interrupt again. I'm so sorry. We are missing Marco.
Miss
No, there's not.
Green. Okay. And where's the child placed at this time?
They're in maternal grandparents' home in Kendall County,
What was the date of that placement?
October 22nd.
All right. And is there a permanency goal in this case yet?
Our permanency goal is family reunification with a concurrent of relative adoption.
All right. Is the placement safe and appropriate, meeting the needs of the children?
Yes, it is.
Is it in their best interest to remain there?
Yes.
And are they both up to date on all their checkups?
Yes, they are pending a dental, and I have sent a referral for a CANS and a psychological assessment. So we're pending that to be scheduled as well.
But you believe all their medical and emotional needs are being met at this time?
I do.
Any observable delays or other issues that we need to take up or discuss today?
No.
Okay. Educational needs being met?
Yes, they are attending the same school, and I was able to figure out their transportation. So they take the bus to and from school.
Okay. Are they attending therapy?
Not yet. We'll see what they recommend after the CANS and psychological evaluations.
Okay. Are they having any contact with either parent at this time?
They are not having any contact with mom as it's been reported to me, but I did learn from CASA that they have spoken with Gina Castro and Mr. Castro as well, just over the phone.
What are you asking for today in terms of contact with the parents?
We would be okay with 1 hour a week or 1 hour every other week, whatever is appropriate and feasible for the caregiver.
Okay. Are the parents cooperating with you at this time?
Mr. Castro, I did just meet with him yesterday for the first time. He was released from TDCJ on November 5th. And he did attend the FGC. He was cooperative, and he did review the family plan with me, but he asked not to sign until he went over it with his attorney first. But with Ms. Castro, I have not had any success meeting with her. I did also offer to meet with her yesterday, but I was not able to.
Okay. So then when you created the plan, the parents weren't actually present and they didn't actually participate in the creation of the plan. Is that correct?
No, they were both there.
Okay.
Yeah, they were both at the family group conference.
So they just haven't signed them yet.
Yes, I haven't sat down to review and have them sign it. Well, actually, I'm sorry. Mr. Castro did review it with me, but he asked not to sign until he went over it with his attorney.
Okay, I understand now. All right, and then Do you believe that these family plans of service are narrowly tailored and in the best interest of the children to make orders of the court?
Yes, I do.
Oh, yeah. Oh, yeah. Oh, yeah.
Ms. Castro, I don't know what you're doing over there, but I need you to keep your video on, please. Mr. Cabrera, could you go ahead and announce for me, please?
Yes, Your Honor. I apologize. Marco Cabrera, I represent Mr. Robert Castro Sr. He's present. We're ready for this hearing. Mr. Castro, if he has not already announced, could you say your name?
He already did. He announced that I swore him in. Ms. Castro, are you there?
Yes,
Can you turn on your video, please?
I'm trying to figure it out.
Okay. Well, in the meantime, while we're having testimony, please don't make any noises out loud. All right.
Yes, Your
Thank you. Can you briefly set forth on the record, Ms. Artuche, what services you want the parents to complete, respectively, starting with the mother?
Yes, so for Ms. Castro, we would want her to address her resource management and basic needs, which includes proof of employment and a monthly household budget, just to prove that she's able to provide a safe and stable housing. And she will provide us the names and identifying information for anyone else that's going to be living in the home or any frequent visitors. She will make herself available for announced and unannounced visits. And she will make sure that we have all of her current addresses if she moves and phone numbers if she changes that as well. And we would also like her to participate in a parenting education course and successfully complete that, as well as demonstrate behaviors learned and implement skills that she's acquired throughout that course. We would also ask for her to submit to random drug testing and complete that within 24 hours. And depending on those results, if she's positive for any results, I will refer her to an OSAR assessment where she will follow those recommendations that include inpatient or outpatient NA/AA classes or substance abuse counseling. We would also like for her to complete a psychosocial assessment and participate in individual counseling, and she will follow all recommendations from the psychological evaluation as well. She will also sign a release of information for Belong so that we're able to obtain information from all of the providers. And I left out the part in parenting education. We would like for her to comply with her visitation when that is started. And then for Mr. Castro, we would like the same thing with resource management and basic needs, just to provide proof of employment and a monthly household budget so that we are able to ensure he has safe and stable housing, and provide us with information for any frequent visitors and allow us into his home for both announced and unannounced visits. And he will provide us with a current address and phone number at all times throughout this case. Mr. Castro will also participate in an education class and submit a certificate of completion to me and demonstrate skills that he learned throughout that course. And he will be consistent with his participation in all of his visitation. And for Mr. Castro, we would also ask for random drug testing. And depending on those results, I will refer him to an OSAR assessment and he will follow the recommendations to that as well. And for his mental health, we would also like for him to complete a psychosocial and psychological evaluation and follow recommendations from that, which may include individual counseling. And lastly, for him to sign a release of information, which he already has.
Okay. And you believe that all of these services are in the best interest of the children?
I do.
All right. As of today, is it safe to return the children to either parent?
As of today, no.
As of today, has either parent fully addressed the concerns that brought the children into care?
No.
So is it in the best interest of the children to remain in the temporary managed conservatorship of Belong?
Yes.
Ms. Thompson, do you have any questions for Ms. Artuche?
Very briefly, Your Honor. For Mila, did she begin her dietary counseling?
No, not that I'm aware of yet.
Okay. Do you know when she's scheduled for that? When is her first session?
I can follow up with that. That recommendation was done when she was at her previous placement. So I have to go over those medical documents and recommendations with the grandparents, but I will do that when I visit with them this month.
Okay. No further questions, Your Honor.
Right. Ms. Yanis?
No questions.
Mr. Cabrera?
Thank you. So just to clarify, your request is for Dad to do random drug tests, and if any of those come back positive, to refer to OSAR?
Correct. That's one of his tasks, yes.
Okay. And has he been, I know he hasn't signed his family plan, but has he been given the referrals and phone numbers to call?
I did provide him with a physical copy of his family plan, and that has all the information of who to reach out to.
Okay. Thank you. That's all I have.
Savage.
Yes, in regards to the visitation for the mom, where would that be located at?
We would try to keep that in Bernie.
Okay, and are you requesting the court that if that visitation is started, that Belong has the ability to end those visits should any behaviors become inappropriate?
Yes.
Okay, and then will Belong work with placement to get sibling visits set up for their older siblings for the children?
Do you mean Desiree?
And there's another sister, a 16-year-old sister as well.
Sure, yeah, that would be okay.
Okay, are there any other orders at this time the kids are needing?
Not at this time.
Okay, I will pass the witness round.
Any follow-up, Ms. Thompson?
No, Your Honor.
Any other witnesses?
No, Your Honor.
All right. Anybody else have any other witnesses? No.
No, Judge.
Report, Ms. Savage.
Yes, Your Honor, I was able to visit with the kids. They seem to be doing well in their placement. They like it at the maternal grandmother's home. The children did specifically ask to see their older sisters. Desiree, I think Cameron was the other sister's name. She is with her dad, not a part of this case. But I do believe she lives in the Bernie area. Robert also asked about being able to visit with his dog. So I don't know if once we get visits set up with mom, maybe we can get that arranged. He seemed very concerned that he hadn't been able to see his puppy in a while. The kids did express wanting visits with mom and their father. My only concern is some of the behaviors if mom doesn't show up sober to a visit. So I would just ask that the department or Belong have the ability to end those visits if any behaviors become inappropriate.
Okay. Casa?
Yes, Judge. I was able to visit with Mila and with Robert yesterday. They're doing very well in their abuela's house. They are happy and healthy and enjoying being back at their regular school. They are doing really well in school. There are no academic or behavioral concerns, and CASA believes that this placement is safe and appropriate at this time.
Thank you. Mr. Tiche, did we make any progress with the inpatient for mom?
No. I did give her information and I called myself to ask, but the one I was given, they were only by private pay or by her insurance. And she is adamant that she needs a court order to pay for inpatient. So we talked about it at the family group conference and we said that if she agreed to take a drug test and take the OSAR assessment, that we could get her into a federal grant inpatient, but she has not done that.
Well, I think the temporary order has an order to inpatient in there, right? I mean,
I'm not
I
sure
ordered
if
it.
that was ordered yet.
It's in my notes.
We haven't received the orders from the last hearing where you did order that.
Okay. Well, that is definitely something I ordered. So once you get that order, that'll help her. But Ms. Castro, can you unmute and turn on your video, please?
Yes, I'm sorry. I'm trying to figure it out.
Well,
I'm
you
sorry.
had it figured out a minute ago. There you are. Okay.
Sorry, I've been crying.
I understand. Can you take a seat for me, please, so that you're still?
I'm sorry. I've been crying. I'm not under the influence. I've just been really emotional.
Okay. Well, we're trying to put some things in place for you and your kids.
I know.
Remember what I told you about? Hey, remember what I told you?
I have requested
Ms.
a
Castro.
court order.
Ms. Castro, remember what I told you about how
Don't
you and I
interrupt.
cannot both talk at the same time?
No, don't interrupt. Yes,
Okay,
I know.
don't interrupt because we don't have time to sit here all day. We have a lot of work to get done in a small portion of time. I've already made some orders at our last hearing, and I'm going to make some more orders today. They're going to help you, if you follow them, fix these issues in your life that are making you cry. If you want to spend more time laughing and smiling and less time crying,
I'm not laughing. I'm not.
No, I'm telling you, I wish you were spending more time laughing and smiling than crying. And the only way you're going to get there is by addressing these problems so that they're not problems in your life anymore. So
I have been begging for court orders for over a week.
well, this court order was rendered on the 30th of October, and it's just barely been a week. The court's going to order.
I drove out 2 hours. I drove 2 hours.
Ms. Castro, I want you to understand something. I need you to listen to me. I am empathetic to people's emotions. I can understand that people have emotions, but I don't make decisions based on people being emotional in front of me. You're not going to get anywhere crying in front of me. It's not going to get you anywhere. Okay, well then you just need to be quiet. You just need to be quiet.
I'm not trying to do that.
All right, well, you need to be quiet.
I'm out, Your Honor, I'm out in Austin.
Okay, you said you're not under the influence, but you can't follow my instructions, so you're starting to make me think that you are.
I'll shut up. I'm sorry.
That would probably be a good idea.
I'm not allowed to get emotional because
I didn't
I'm
say
under
you
the
couldn't get
influence.
emotional. I said it's not going to make a difference on my decision. All right. Court finds that for the purposes of the status hearing, there's no Indian child heritage in this suit, that the permanency goal of family reunification is in the best interest of the child with the concurrent goal of relative adoption. Court finds that the placement is safe, appropriate, meeting the needs of the child, and in the best interest to remain in that placement. Court finds that the children are up to date on their medical and their vision. However, they are still pending a dental, CANS assessment, and psychological evaluations. Court finds that there are no observable delays or other issues at this time that have not already been addressed. Court finds that their educational needs are being met, that they're attending their original school, and that they have transportation to and from school. I'm going to continue my order that they have no contact with the mother at this time until she engages in services and goes to inpatient. Court is observing today that she appears that she's still under the influence. She cannot control her actions or behaviors or her emotions at this time. I don't think it's in the best interest of the children to be subject to that while they're trying to deal with all the other issues that they have going on at this point in time. I'm going to maintain that once she engages in services, she goes to inpatient and she's able to have visitation. She can do 1 hour a week or 1 hour every other week as feasible for the caregiver. That goes for Mr. Castro as well. I'm going to find that there were family plans of service narrowly tailored to address the concerns that brought the children into care. The parents participated in the creation of those plans. They have reviewed them, but have not signed them yet. I'll find that those plans are in the best interest of the child. Find that Mr. Castro has been cooperative with Belong. Ms. Castro has not been cooperative. And I'm going to find that both parents remain indigent for the purposes of this case. The court will order or distribute a pretrial scheduling order and a discovery control plan with the dates and times of future hearings, as well as rules and deadlines for discovery. Please review those and assign those accordingly. I have to admonish the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence, and drug-free home. In the event you cannot, your rights to your child are subject to restriction or termination. Ms. Adversary, let's work with Ms. Castro and let's do everything we can to get her a bed and inpatient. If she doesn't cooperate, she doesn't cooperate. But if you can help her secure a bed and get her that information, get it to Ms. Yanis as well in writing so that you can show you provided it to her and or her attorney. I think that's all we can do at this point. It's up to Ms. Castro whether or not she wants to cooperate. She wants to take advantage of those services that can help her get sober. Our next hearing is going to be March the 12th, 2024 at 11 a.m. March 12th, 2024 at 11 a.m. Ms. Thompson, is there anything I failed to address?
No, you covered everything, Your Honor.
Okay. I see Ms. Gina Castro raising her hand. Ma'am, you're here as a non-party without counsel, so I just want to caution you that I don't know what you're going to ask about or what you're going to say, but I just want to make sure you know that there's certain rules and procedures we have to abide by. So do you have a question or do you want to offer information? Okay, what is your question?
Am I allowed to see the kids?
Okay, that is something you need to talk to their attorney about, Ms. Savage, and
Okay.
talk to Ms. Adversary about.
Okay.
I certainly, they've expressed an interest from what I heard in wanting to talk to people, and that includes you and your son. So y'all talk it out, and as long as everybody agrees it's in the best interest of the kids, I don't have a problem with it. I just
Okay.
want to make sure it's safe and appropriate.
Thank you.
I think considering they're not able to see their mother right now, it might be very helpful for them to talk to their grandmother. Okay. Anything else I failed to address from anyone? Okay. I don't think that she really understands me right now. I think she's under the influence, and I want it on the record that I believe she appears to be under the influence. But I want Ms. Castro to get into inpatient. I want her to get help. I want her to have contact with her children. That's truly what I want. But right now I feel like it's a safety risk. So I'm not going to allow it until she goes to inpatient. Thank you all for your time and your service. If nothing further, all parties are excused, and have a great weekend.
Thank you, Judge.
Thank you.